Great win for democracy. I mean, this case really says that the elected representatives of the people of Tennessee and not federal judges are the ones who ought to be making these policy calls.
Tennessee's Attorney General Jonathan Skrmetti celebrates a win at the U.S. Supreme Court with a case centered on gender transitions for minors. It's one of many across the nation we're closely following. The U.S. Supreme Court upheld Tennessee's right to protect minors with gender dysphoria from transition procedures like puberty blockers and so-called hormone therapy. Welcome to EWTN News In Depth. I'm Catherine Hadro. 3 Tennessee families and a doctor originally challenged the state law. The Biden administration joined them, arguing the law discriminated based on sex in violation of the 14th Amendment. Tennessee insisted the law distinguishes based on a treatment's medical purpose, not sex. In a 6-3 decision, the High Court ruled Tennessee's ban on gender transition procedures for minors can remain in place because it does not amount to sex discrimination. Skrmetti says the decision protects minors from experimental procedures. Many in the LGBTQ community argue they have a right to make their own medical decisions.
This is about parental rights, and this is about taking away the rights of families and parents and caregivers from making those decisions with their doctors, with their families.
If you look at countries that actually follow the evidence, as the Tennessee legislature did, you see countries like the United Kingdom and Sweden and Norway, which are very politically different than Tennessee, who came to this conclusion not as a result of a culture war, but because they want to protect their kids, and they have seen evidence that these radical interventions cause lifelong harm. There's huge risk and very little, if any, benefit shown by the research.
25 other states across the U.S. have similar protections against using life-altering hormones and puberty blockers to treat gender dysphoria in minors. These controversial treatments are still available in states without the bans. The Catholic Church is clear gender transition is a grave violation of human dignity. The Vatican document Dignitas Infinita, or Infinite Dignity, which was released last year, states in part, we are called to protect our humanity. And this means, in the first place, accepting it and respecting it as it was created. It follows that any sex change intervention, as a rule, risks threatening the unique dignity the person has received from the moment of conception. Mary Rice Hasson, Senior Fellow at the Ethics and Public Policy Center, where she co-founded and directs the Person and Identity Project, joins us now to dive further into the implications of this decision. Mary, welcome back to the show. What does the Supreme Court ruling mean for the national debate on gender transition treatments for minors? Put this week's ruling into context for us.
Sure. Thanks for having me. I mean, this is a tremendous win. I think it really puts the momentum on the side of those who are trying to protect children. And what this ruling does is it signals to the lower courts, because there are about 27 states that have similar statutes, including Tennessee's, but 27 states. And in many of those states, they have been challenged in court and even enjoined from being enforced. So what this decision says to those lower courts that may be already entertaining challenges is that these laws should be upheld as an appropriate exercise of the state's authority. The legislature weighed the evidence and concluded these interventions were harmful to children, and so it's perfectly appropriate for the state to regulate medicine in this way.
Mary, in Justice Clarence Thomas's concurrence, he writes in part, quote, this case carries a simple lesson. In politically contentious debates over matters shrouded in scientific uncertainty, courts should not assume that self-described experts are correct. Mary, what is Justice Thomas really saying there, and how consequential is that?
Actually, it was a tremendous point that he made, and he spent a fair amount of time on it. His opinion went through what happens in so-called transition, the evidence related to it. But his real point was this. He was saying to the courts that you should not defer to the so-called experts. He pointed out that many experts have ideological motivations, but really it's not the role of the courts to weigh the correctness of the experts. That's the role of the legislature, and that courts need to step back and allow the legislature to do their job.
How have those self-described experts responded to what Thomas had to say?
Yeah, it's been disappointing because we have seen over the past couple of years just mounting evidence, particularly from Europe, but even increasingly here in the US, study after study showing that these interventions are tremendously harmful to vulnerable young people. But instead, right after this decision, within hours, we had a statement from WPATH, which is the transgender lobby organization, from the American Academy of Pediatrics, from the APA, the Psychological Association, saying, basically doubling down and saying, no, we believe these interventions are evidence-based and medically necessary, even though neither of those 2 points can be supported by the evidence. And certainly the court's ruling really cast a lot of shade in that direction. But I think what they're telling us is that they're committed to the ideology that fuels this. And I think they benefit from the profits that are made from the bodies of very vulnerable young people.
Mary, Justice Amy Coney Barrett, in her concurring opinion, said people who are transgender do not have immutable characteristics. Can you expand on what her point is there?
Yeah, that was a very important point. It actually came out in the oral argument where Justice Alito sort of cornered the ACLU attorney and said, you can't really say this is immutable, right? Because we see detransitioners who, just by the very evidence of their lives, show us that having this feeling of transgender identification doesn't always persist. But it was significant that Justice Barrett really doubled down and analyzed this, because the majority opinion declined to address that question. And so what the value of what she did is that her analysis is going to guide the lower courts, because many of them are facing those and called to adjudicate that claim of transgender activists that transgender status, as they say, it should be a protected characteristic, which means the government would have a much higher burden to show that their law is legitimate. And which her analysis was very clear. She spent a lot of time and went in depth, and she said, when courts have accorded protected status to a particular characteristic like race, they look at things like whether this is innate, whether it's immutable, whether you can define the class of people by this characteristic. And she said the transgender identification, the transgender status just does not meet those criteria, not one of them. It's not immutable, it's not innate, and it's really hard to define. Justice Thomas joined her opinion. Justice Alito agreed in that. He had a slightly different analysis, but that's significant guidance to the lower courts.
Mary, we are so grateful for your voice on this week. Thank you for joining us.
Thanks so much for having me.